Welcome back, everybody, to our study in the law of contracts. In this lesson, what I want to do is talk a little bit about the Officious Bystander test, which is a test which relates to the implication of terms, i.e., implying terms into contractual arrangements. And this is only going to be a short lesson, given the fact that this is not a particularly complicated or convoluted test. And we'll just recap some of the things that we've been talking about in the previous lessons, and we'll talk about essentially the roadmap for the next few lessons as well at some point in this lesson too. So, the previous lesson introduced the subject of implied terms. We noted about the ways in which a term may be implied by a court. We had noted that when we talk about implying terms, there are three main ways which terms can be implied into a contract when it comes to the sort of practical implication of a term. Firstly, being implied by courts. Secondly, being implied through custom. And then thirdly, being implied through the imposition of the Consumer Rights Act from 2015. And then, when talking about the first of these prongs in relation to the implying of terms, implying terms by court can either be done through fact, implication by fact, or implication through law. So, one of the things that we noted is that implied terms in fact can be established if they would be efficacious for business purposes. We talked about the case of the Moorcock, in which you have the defendants being the owners of a jetty, you being the claimants being the owners of a ship that was unloading at the jetty, and it was argued that there was an implied term that the defendants take reasonable care in ensuring that there would not be damage done to the ship itself. And it was seen that this would be efficacious for business purposes rather than just be desirable. It's struck at the heart of the contract itself. This lesson is going to talk about the second process by which a term may be implied in fact, this being the Officious Bystander test. So generally speaking, when we think about terms implied by courts in fact, there are two routes in which you can go down. You have the efficacious business test, and then you have the Officious Bystander test. What the Officious Bystander test tells us is that we can imply terms which are considered to be so obviously part of the contract that it goes without saying. So it doesn't necessarily relate to the conduct of the potential efficacy of the business practice or the necessity of the business practice in order for a term to be implied into a contract. But it's really something that is just so obvious. It's so obvious that this term has to be part of the contract itself that the idea of it not being the part of the contract doesn't make any sense whatsoever, and therefore we can imply in fact the existence of this term through courts. It goes without saying that this term is required for a contract. It is called the Officious Bystander test because it comes from the case of Sherlaw and Southern Foundries Limited from 1939. Specifically, this quote. They say, quote, "Prima facie, that which in any contract, if left to be implied, is something so obvious that it goes without saying, so that if, while the parties were making their bargain, an officious bystander were to suggest some express provision for it in their agreement, they would testily suppress him with the common, 'Oh, of course.'" So, essentially, what this test requires us to do is to imagine, let's say, that we are at a cafe and that I am a random bystander that's listening in on the negotiations of a contract between two people. And I go up to them and say, "Oh, by the way, this term should be in that contract." And that they respond with, "Oh, of course it should be. Of course it should be." That is essentially the Officious Bystander test, such that any bystander any reasonable bystander that would just be able to happen upon your conversation with another person negotiating a contract would know immediately upon knowing the express terms in the contract, they would know immediately which other terms should be part of the contract, and that when those terms are cited by this officious bystander, the people negotiating the contract would have said, "Oh, of course, what a silly idea," and to not have this in the contract. So that's what the officious bystander test means. That's where the phrase comes from, and that's where the word comes from. Essentially, what you do is you associate yourself with a negotiating partner at a table in a restaurant. You are assuming that you are negotiating a contract, and the negotiations are overheard by an officious bystander. And if the said bystander were to ask if the contract was going to have X term in it, and you both respond in the affirmative, then this term will be implied in fact by the courts. That's essentially what the officious bystander test tells us. And what it means, therefore, is that these are terms that are so obvious that they have to be a part of the contract, that they are almost de facto and prima facie in the contract, just through the nature of the contract itself, through the nature of the contract and the facts of the terms of the contract that are expressly cited. And so as a result of that, that's why we determine that this is a way in which the courts can imply a contract imply a term in fact. If you look at the facts of a contract, you look at what the contract says, and you go, well, this term has to be in it, because if it doesn't, then it doesn't make sense, then this is an implied term through the officious bystander test.